the earnings from television shows. Did you analyze what historical earning Ms. Heard had during the period that you were concerned with relative to television shows?
Well, yes. During 2019, she entered into a contract in July of 2019 to appear in a television series at $200,000 per episode.
All right. What about endorsement deals? Did you look at what she had made on endorsement deals during that period?
She did have a contract with L'Oreal at $1,625,000.
All right. With respect to her movie roles, what were her historical earnings during that period?
Well, certainly for the most recent years, you had the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000. Then the first Aquaman was $1 million base fee. Then $2 million for Aquaman 2. And presuming that there was an Aquaman 3, that would have been $4 million.
Okay. Why do you look at historical earnings as part of your analysis?
Because you want your analysis to be anchored in facts. You want it to have a sound methodology, and you want to come up with a reasonable result. So if you take a look at, for example, the analysis that Ms. Arnold did, it didn't appear to be...
Let's just look at the analysis that you're doing. What you said, I think, is you wanted them anchored in facts. Why?
Because that provides a sound basis for coming up with something with reasonable certainty. There's AICPA, or American Institute of Certified Public Accountant, guidance with respect to reasonable certainty. And those are the basic elements of it.
Thank you. No further questions.
All right, cross-examination.
Hello again, Mr. Spindler.
Good morning.
I'm going to ask you a few questions that may refer to the statements in Amber's counterclaim against Mr. Depp. When I refer to those statements, I'm going to refer to them as the Depp-Waldman statements. Do you agree that we can both be on the same page what I'm referring to when I say that?
That's fine. You can use your terminology.
I'm sorry, there's an objection, sir. Hold on.
Can we approach?
Okay.
So, Mr. Spindler, when I refer to the Depp-Waldman statements, you understand me to be referring to the statements in Ms. Heard's counterclaim against Mr. Depp, correct?
I'll understand that, yes.
Now, you're here to provide a rebuttal opinion to Ms. Arnold's, part of Ms. Arnold's testimony, correct?
Correct.
You're not providing an opinion on whether Ms. Heard saw Mr. Depp, correct?
That is true.
You're not offering an opinion as to what any of the underlying facts relating to whether Mr. Depp abused Amber, correct?
That's correct.
You're not offering an opinion as to the magnitude of damages that you believe Ms. Heard may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Ms. Arnold has said, correct?
That's correct.
And you said that you want your analysis to be accurate in the facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earns in one period isn't necessarily reflective of what he or she may earn in future periods, correct?
Correct.
And that's because
there can
an
be some
increase in the
variability.
number of roles,
Yes.
an increase in the number of roles may lead to greater income, correct?
I'm sorry. Could you repeat that? I was speaking. I didn't hear.
One of the reasons that what you earn in one period may not be reflective of what an actress may earn in future periods is because an increase in the number of roles may lead to greater income, correct?
The number of roles or the particular project itself, yes.
Sure, getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile grows, the amount of money that she may be able to earn from endorsements grows as well, correct?
It can.
So
It depends.
what Ms. Heard earned from, say, 2013 to 2019 that you testified to isn't necessarily reflective of what she might earn over the next 5 years, correct?
Not necessarily. It is a good indicator, though.
And you'd agree that from 2013 to 2019, in terms of earnings and star power, that Ms. Heard's career trajectory was on the upswing, correct?
There was a slight increase during that period of time in her earnings from 2013 through 2019.
And you'd agree that that was as a result of getting more lucrative roles, right?
Yes,
Now, you're not a causation expert, right? You're just a damages expert.
that's correct.
So you're not testifying as to whether the Depp-Waldman statements caused her to lose any roles, correct?
That's correct.
And you're not offering any opinion as to whether the Depp-Waldman statements kept her from being considered for roles that she otherwise would have been considered for, correct?
That's correct. I'm not testifying on causation issues.
And you can't speak to what opportunities may never have materialized for Amber as a result of the Depp-Waldman statements, correct?
Yeah, I've not done those calculations.
And you don't have an opinion about whether or not Ms. Heard could have renegotiated a contract for Aquaman 2, correct?
That was not part of my work.
And you don't have an opinion on the impact that additional exposure or press coverage or magazine covers or interviews would have had on Ms. Heard's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
You've never served as an expert witness before to calculate damages based on lost roles by an actress resulting from defamation against that person, correct?
I've been involved in defamation cases, but I've not done the calculations as an expert witness and testified thereto.
And there's never been an instance in which you have served as an expert witness in a case to calculate damages based on alleged defamation against an actress, correct?
Correct.
And you're not offering any expert opinion on what impact the alleged defamation by Mr. Depp has had on Ms. Heard's career, correct?
I'm sorry, one more time?
You're not offering any expert opinion on what impact the Depp-Waldman statements by Mr. Depp has had on Ms. Heard's career, correct?
Other than taking a look at Ms. Arnold's calculations.
And you're not offering any expert opinion about what impact, if any, social media coverage of this case or of Ms. Heard may have had on Ms. Heard's career, correct?
Correct. That's other experts.
Can we approach
No
Your
further
Honor?
questions. Thank you.
All right. If you want to approach.
For you.
Okay.
All right, thank you, Mr. Spindler. You can
Thank
have a
you.
seat in the courtroom, or
Thank you,
you're free to
everyone.
go. Thank you. All right, your next witness.
Plaintiff calls Doug Banya, Your Honor.
Okay. Can you spell the last name for me?
B-A-N-I-A.
Thank you. All right, so you can. So just a reminder that you're still under oath, okay, sir? Thank you.
Good afternoon, Mr. Banya.
Good afternoon.
Can you briefly reintroduce yourself to the jury, please?
Yes, hi, Doug Banya. I am from Nevium Intellectual Property Consultants based in San Diego. I value intellectual property. I provide litigation support in infringement and defamation cases, as I'm doing today. And I use internet and social media analytics in both of those services.
Since you last testified in this case, the jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony?
Yes.
Were you asked to analyze their testimony and provide opinions in response?
Yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
I have.
Generally, what are those opinions?
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman statements and the hashtags and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics investigation, I've concluded that the alleged comparable actors that Ms. Arnold came up with are not comparable with Ms. Heard. And then thirdly, Mr. Schnell and Ms. Arnold both failed to provide any evidence of a causation as it relates to the Waldman statements causing any economic harm to Ms. Heard.
Let's dig into those opinions a little bit. You're familiar with the testimony of Mr. Schnell that there are more than 2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell identified those particular 2.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative towards Ms. Heard. Those hashtags range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and the hashtag, we just don't like you, Amber. So then he used those hashtags and he searched through, using the Twitter API, searched through various tweets and then came up with any tweets that were using those hashtags.
Did you conduct an analysis of those tweets?
Yes, I was given that exact, the data that Mr. Schnell used on a hard drive. So yes, I dug into that data as well.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point is, were these tweets, did they contain the Waldman statements? That's what where we're at right now, are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the Waldman statements are?
So my understanding is there's three Waldman statements that were published in the Daily Mail. The Daily Mail is a UK tabloid, and Mr. Arnold was quoted in three of those articles, and those dates were on April 8th, 2020, April 27th, 2020, and on June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Did you analyze the timing of the tweets that we were talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates that they happened, and then analyze those as compared to the Twitter data that I had.
Have you prepared a demonstrative that reflects that aspect of your analysis?
Yes.
Your Honor, may I approach?
Yes. Did you show counsel? So 1293 will just be marked for identification as demonstrative and can be published to the jury.
Mr. Banya, can you explain to the jury what this demonstrative shows?
Yes. So this shows the total hashtags and tweets that Mr. Schnell was analyzing. This is the summary data. There are tweets that are running from January 2018 to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as this, when I'm dealing with a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 30,000-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about the data. And the first thing that I noticed is 35% of the tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets that Mr. Schnell analyzed. So obviously, if these tweets were prior to the Waldman statements, in no way could they have anything to do with the Waldman statements. So that was the first issue that I noticed. Then I noticed what I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statements were published. That's the date down here. You know, the first one was in the beginning of April, and the last one, which is the third one, was at the end of June. But what I found interesting is only 2% of all of the tweets happened during this Waldman statement period. So really, these are just observations, and for me, there were red flags that I made note of, and then I just continued with my analysis.
What other work have you performed in connection with forming your opinions about the purportedly negative tweets?
Yeah, so now I realize that 35% are irrelevant and 2%, only happened during this important period. I just continue to dig into the 2.79 million tweets that Mr. Schnell provided.
And Tom, can we take that one down? And Mr. Banya, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
Okay, yes. Okay, we'll just see if he has an objection. I'll give you time to look at it, sir. All right, plaintiffs. Microphone, I'm sorry.
No objection as a demonstrative.
Okay. All right. Plaintiffs Exhibit 1294 will be marked for identification as a demonstrative and will be published to the jury.
Thank you, Your Honor. Mr. Banya, can you explain what this demonstrative shows?
Yes, this is showing the various spikes as it relates to the hashtags that Mr. Schnell testified about. This is actually a demonstrative that he used in his testimony. What this is showing are the largest spikes related to the hashtag Justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other three hashtags did spike at the same time, but a very small spike. So what I'm showing you here are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first spike and the largest spike, again, happened before the Waldman statements. So what I'm trying to figure out is what tweets were related to the Waldman statements. So this #1 spike, which is the biggest spike, was prior to the Waldman statements, so it's irrelevant to the case. And then the second thing I noticed that was interesting here is here are the dates in gray right here This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for such a viral event that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman, his statement came out here in the first April 2020 article. Then the second one came out here, and then the third one came out in June. There's actually a downward use of the spike, downward use of the hashtags. So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is I looked at the 6 different spikes, and you're going to notice that each spike represents a month. So the second spike, is July of 2020, and so on to the 6th spike going to April 2021. And what I did is, I don't know if you remember my last testimony when I went into Google search, and I'm able to go into Google search. I went in and I typed in Amber Heard. And then after you hit search, you can use the tool and you can go back in time. And I chose each 6 of these dates to go back in time to see what was the media talking about back then. What was the general public being fed as it relates to Amber Heard back during those spikes. And what I found is none of them. Well, actually, I analyzed the top 3 search results because they represent 50 to 70% of what people click on. And I realized that none of them had anything to do with the Waldman statements.
Are you aware of Mr. Schnell's testimony that the tweets using the 4 hashtags he looked at were mathematically correlated?
Yes.
What does that mean?
So what Mr. Schnell is saying, which is irrelevant to this case, is the 4 hashtags that he randomly chose, they tend to go up and down together, and that's why he had these spikes here. So the correlation there is how those 4 hashtags work or dance together going up and down. But first of all, the hashtags have nothing to do with the Waldman statements. And the fact that there's a correlation with the hashtags is irrelevant to this case because we're dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
How do you know that the correlation doesn't have anything to do with the Waldman statements?
Can I clear this at all? No. Oh, yeah. Well, first of all, I know because that would happen right here. If when Mr. Waldman, one of his quotes was published, you would see a big spike right here. And then you would see maybe a little noise down here, and then the third time you might see second time a big spike, and the third time a big spike. That's not here. So that's telling me there's no correlation between the Waldman statements and this hashtag use. And then I've actually provided evidence that there's no correlation because I analyze each of these spikes and none of them had to do with the Waldman statements.
Is mathematical correlation the same as causation?
No.
Why not?
I mean, correlation is simply a relationship between 2 or more variables or 2 or more things. In this case, the correlation question is, when the Waldman statements were published, at the same time, did you see a correlation with spikes in these hashtags? And again, can we clear this? You see none of that right here. It's actually a downward trend. There's no spikes, there's no correlation. So, again, Mr. Schnell provided no evidence of any correlation.
What correlation opinion did he provide during his testimony?
Well, he provided the correlation that the 4 hashtags, spike together. But again, the hashtags have nothing to do with the Waldman statements, and the facts that they're correlating or moving together is irrelevant to the case because the case is about the Waldman statements.
So what is causation then?
So causation is where one thing causes a change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard to have economic harm? In other words, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold provided no evidence of this. And as a matter of fact, during Ms. Arnold's testimony yesterday, she didn't even know what causation was. You know, she was asked, do you know the difference between causation and correlation? And she said that she's not a semantics expert. We're not talking about the words. You know, when it comes to damages, you have to prove causation prior to calculating damages. You know, so there is no causation that's proven here. Therefore, a damages analysis is not appropriate.
Did you hear Mr. Schnell testify that he agreed with your opinion in this case?
Yes.
And what's your understanding of the opinion that he agreed with?
Well, he agreed that he failed to link the spikes in the hashtags on Twitter to the Waldman statements.
Did he try to do that?
He tried to do that. But again, his analysis was looking at the word Waldman and looking at the word Waldmanian, and then trying to say that 25% of the tweets included those two terms. But first of all, Waldman isn't the issue here. It's the Waldman statements. And Waldmanian, I don't even know what that is, but it's not relevant to this case.
We can, I think, take that one down, please, Tom. Mr. Banya, what other work have you done in connection with forming your opinions about Mr. Schnell's testimony?
Again, the assignment was to determine if the Waldman statements were part of the tweet, so I continued to dig in, to the data. I believe the next step is, now that I've excluded, the 35% that was before the Waldman statements because they were irrelevant, I wanted to really analyze from the April 2020 forward to see if any of those tweets, contained the Waldman statements.
Did you prepare a demonstrative that reflects that analysis that you did?
Yes, I did.
Your Honor, may I approach again?
All right. Yes, ma'am. Any objections, sir?
No objection as a demonstrative.
All right. We'll mark it for identification as plaintiffs 1295 as demonstrative and publish to the jury.
So, Mr. Banya, did you consider the content of the statements made by Waldman as part of the work that you did?
Yes. Yeah, so here I reviewed the Waldman statements again, and what I wanted to do is I wanted to determine what, if any, tweets included the Waldman statements. So what I went back to the Waldman statements, and I came up with key terms and key themes for those Waldman statements, which are listed here. The Waldman statements were about abuse hoax, sexual violence hoax, and fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets because we're starting in April 2020 because that's when the Waldman statements started. And what I did is I searched the 1.2 million tweets, for these three phrases. And I determined that there were 751 tweets that included those key terms, which is 0.06% of the 1.2 million. And then as I was sifting and sorting and analyzing this data, I realized that a lot of these tweets had the exact same language. It was interesting to see it was the exact same tweet because I'm analyzing the language to see if it matches one of these three. I realized that a lot of these tweets were retweets, likes, or shares. So therefore I eliminated any of those, and it came down with 95 unique tweets. And then what I did from there is I analyzed those to determine if any of these terms were in there, and I identified 5 tweets that were related to the Waldman statements.
Do any of the hashtags Mr. Schnell analyzed include the words from the Waldman statements?
No, they don't. And, because I am rebutting Ms. Arnold, her testimony yesterday, she was saying that the Waldman statements caused these hashtags. Then throughout her testimony, she walked that back and admitted, no, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. These hashtags are only hashtags that Schnell, in his opinion, felt that they were negative towards Ms. Heard.
Based on your expertise, what are your overall opinions about Mr. Schnell's testimony and the Twitter hashtag data?
Mr. Schnell provided no evidence that any of the tweets were related to the Waldman statements. Mr. Schnell, there's no correlation there. He also provided no evidence that there's any causation that, the Waldman statements caused any economic harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to break now or push.
All right, it's going to be a little while, I assume?
A little bit more, yes.
Okay.
Yeah.
Let's go ahead and break for lunch, ladies and gentlemen, okay? Do not discuss the case and do not do any outside research, okay? All right, we'll come back at 1:40 then. Is that right? All right,
Thank you, Your Honor.
All right.
right, welcome to a very special For the Record, everybody. I'm Jesse Weber. I'm here with Gene Rossi. We are live in beautiful Fairfax County, Virginia right now, outside of the Fairfax County Courthouse, where they're currently on a lunch break in day 21 of the Johnny Depp Amber Heard defamation trial. I will tell you, I think this is my favorite part of the day because this is the day, this is the hour when we take questions from you. So all our viewers right now on YouTube, Twitch, Twitter, Facebook, however you find us, please submit your questions, pin them on the channel, tweet us, email us. We are going to take your questions for the next hour, and we will answer all of them. I'm not only here with Gene Rossi, I am also here with Anjanette Levy. I'm here with litigator and legal analyst Richard Schoenstein, and I'm also here, of course, with Linda Kenny Bodden. So we have the full dream team with us. We're going to take your questions. Please submit them this hour, and we'll answer any questions you might have about the Johnny Depp Amber Heard trial. But really, the place that we have to start off is what happened earlier today. There was a motion that was argued by Johnny Depp's team to dismiss Amber Heard's counterclaims. Remember, she's countersuing Johnny Depp for $100 million. Here was the judge's decision regarding that.
In this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered an motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are issued in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship is enacted in part to service the principal can be held liable for the tort. Here the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail Online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay?
All right, so those counterclaims will move forward for the jury. All right, ready to take some questions, Gene? The first one's up to you. This is from Life and Times M from Twitter. At the start of Johnny Depp's attorneys, they asked to strike out Amber Heard's motion for defamation, citing previous Virginia cases. Is there any precedent for them to use cases or examples outside of the state of Virginia?
Oh, that's a great question. When you're in a state court in Virginia, the judge has to abide by the upper court's decisions, stare decisis. You can go outside of Virginia, or you could use a federal case as persuasive authority. The judge here does not have to follow it, but it's persuasive. So I saw some citations to the Eastern District of Virginia Federal Court. I worked there for almost 20 years. It's persuasive. It's not stare decisis. It's not binding.
Gene, I feel like you have an encyclopedia mind of all the cases. You don't need LexisNexis. You don't need any of it. We got Gene Rossi.
I wish.
All right, I hear Anjanette Levy laughing. So, Anjanette, you're now in the hot seat. We have a question from YouTube from Jimp164. I thought Heard's team was going to call Johnny to testify today. Why didn't they do it?
Well, you know, we haven't received a clear answer on that, Jimp, but we were telling you for the last 2 weeks that they were going to call Johnny Depp to testify. And if Amber Heard had done that, Johnny Depp would have been considered an adverse or hostile witness. And the only reason they would have called him would really have been to question him about Adam Waldman. His conversations with Adam Waldman, you heard Judge Ascarati referencing him and the statements that were made to the Daily Mail back in 2020, along with the tweets. And Johnny Depp is the only one who can really, you know, break that attorney-client privilege and talk about what they discussed and whether Johnny Depp said to Adam Waldman, go to the Daily Mail and tell them I didn't do this and say it was all a hoax. That is the basis of Amber Heard's counterclaim. We were told over the weekend they were going to call Johnny Depp. I wrote up a web story for lawandcrime.com detailing why they were likely going to call Johnny Depp to the stand. We all anticipated it. Then yesterday we received this word that they were not going to call him anymore, that they considered him as irrelevant as a bicycle to a fish, a feminist reference, right, and that everything he had said had been irrelevant. So they obviously made some type of decision not to call him. We don't know if it was because of time, because they didn't have much time left and they don't have much time left, or because maybe, you know, Catherine Lizardo and I talked about this, the fact that he did well on the stand.
Could very well be the case, but if you focus on the time, Rich, I want to go to you now because we have a question from Ross Cameron from Twitter that asked this very question. Why would Amber Heard's team not have been more conscious of their time if they knew there's multiple other witnesses for Depp? If a witness says something on objectionable grounds, can they still object even with no time left?
I think they can probably object. I don't think that counts in the time limit, but they can't cross-examine if they run out of time. And I'm finding the time management by Amber Heard's team to be agonizing as a lawyer, as a trial lawyer watching this, to see them fritter away the hours on an unproductive cross-examination of Johnny Depp, struggling to get exhibits into evidence when they had Amber Heard on the stand, and other places where they just lost precious minutes and hours, and now they're under 4 hours left and they have 2.5 days of trial. I don't know what they're going to do.
Yeah, and people have a lot of questions about the procedural aspects of this case and the time limits. In fact, Linda, we have a question from Twitch. This is from one of our viewers on Twitch, from Crimson Witch 20. We saw Amber passing notes to someone in the gallery through a member of her team. Is that legal?
I'm sorry, Jesse, I couldn't hear the last part of the question. Is that?
Is it legal for Amber Heard to pass notes to somebody in the gallery?
It is because she's not in custody. Usually the cases we have here are the long crime network. You know, you're sitting next to somebody accused of a homicide, and that would be improper. But because she's not in custody, yes, she can pass as long as Judge Escarati has not put any limitation on that, and that is perfectly legal whether you like it or not.
Well, Gene, you know, usually these are kind of procedural questions.
Right.
Maybe not so biased. This next question, a little biased. We have about a minute left. I want to get it to you. Kimberly Fine from Facebook. For Gene, I know you guys have pointed out how rarely perjury charges are pursued, but do you think this may be an exception considering the massive scope of the trial, fraudulent charity donation claims, as well as the exploitation of the Me Too movement, subsequently making claims even more difficult, I think survivors' claims even more difficult for current or future victims?
Kimberly, it's a great question. We're sitting in front of the Fairfax County Courthouse. In that building is the lead prosecutor, Steve Descano. It's a huge office. I doubt very seriously the prosecutors in the county of Fairfax are going to look at this case and file perjury charges against Amber Heard or anybody else. It just doesn't happen. It's extremely rare. What happened under Ken Starr and Bill Clinton, that was an anomaly. That won't ever happen either. So it's extremely rare. It's a civil case,
Right.
Resolve it, move on, and prosecutors got other fish to fry.
Doesn't mean you should lie on the stand. Do
Right.
not lie on the stand.
That's
Just
right.
because it might practically not happen. Do not lie. All right, we're taking more of your questions on YouTube, Facebook, Twitch, however you want to send them to us. We're going to take a quick break. When we come back, me and my all-star panel are going to answer your questions in real time. We'll be back. Welcome back, everybody. We are joining a very special day. This is the Q&A session that we have every day here during the Johnny Depp Amber Heard trial when they're on a lunch break. Gene Rossi and I are outside of the historic Fairfax County Courthouse, currently on a lunch break. I'm also here with Anjanette Levy, Rich Schoenstein, Linda Kenny Bodden, and we are taking your questions about the Johnny Depp Amber Heard trial. If you're on Twitch, Facebook, YouTube, Twitter, email us, message us, pin the questions. We will answer them in real time in the next hour. So we're moving on to some of the testimony that you might have missed. And today was very much about the damages that Amber Heard said she sustained as a result of the statements that Adam Waldman, Johnny Depp's attorney, had made. They're part of her $100 million counterclaim. She is arguing that as a result of these statements that she says are attributed to Johnny Depp, she lost significant career opportunities. She lost millions and millions of dollars of money. Well, Walter Hamada, who is an executive producer, big exec at Warner Brothers, particularly with the distribution of the Aquaman film, he was talking a little bit more about this, the issues associated with Amber Heard and Aquaman, and what we didn't hear was that it had anything to do with Johnny Depp. Let's take a listen.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there, and would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way.
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
At any time from the beginning of history through today, Did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up her option.
So clearly that is testimony that discredits an Amber Heard witness who testified previously about what was going on with Amber Heard's contract, but also it makes it look like what was the real harm to Amber Heard in this defamation case. All right, and Jeanette, I'm going to throw this one at you because we talk about curveballs being thrown in this case. Christina Palmieri from Facebook, who I believe has written in before, so Christina, we appreciate it. What does it mean for Kate Moss to go up on the stand tomorrow? And will what she says discredit a lot of accusations Amber has made towards Johnny Depp? This was a big development this week, Kate Moss taking the stand.
And Jesse, you'll recall, we talked about this as soon as Amber Heard said Kate Moss and the stairs in her testimony. We showed you the fist pump from Ben Chu, the smile from Johnny Depp, and we told you that Amber Heard had opened the door to Kate Moss coming in on rebuttal. Kate Moss is, obviously I don't know for a fact, but Johnny Depp has said he never has hit a woman or harmed a woman. And Kate Moss has been quoted in news stories, magazine profiles, as saying that she loved Johnny Depp and she cried for years when they broke up. And she said he was the only person who could ever really take care of her. So I think that Kate Moss is going to get up on the stand live via video link tomorrow and tell this jury that Johnny Depp never threw her down a set of stairs, as Amber Heard suggested in her UK testimony. She said that she had heard a rumor that from two people that Johnny Depp had tossed Kate Moss down a set of stairs. And she may also be allowed to talk about his behavior toward her during their relationship, which she said she cried for years when they broke up. She loved him.
That is definitely helpful testimony. Clearly, they were excited about getting her on the stand. Okay, so Rich, I want to focus on Mr. Walter Hamada, who we just heard from. We have a question from one of our followers on Twitch, Sean STLE. Mr. Hamada revealed confidential conversations regarding Aquaman because he was under oath. Is there a circumstance where he could refuse to answer those questions for fear of hurting his business and the reputation of the actors involved? I think this is a great question, Rich, because Richard Marks, who we had just testified earlier today, said he was even surprised that Mr. Hamada made these kind of revelations on the stand. So what do you make of that question?
Well, there are a lot of circumstances where there are witnesses in cases who don't want to talk about things that are confidential business matters. And usually the way that's handled is there's some kind of protective order put in place so that they can testify that at deposition and the like. And usually the protective order will say that they can testify about it at trial without being, in fear of any repercussions. The point being that you need to get the facts on in front of the jury, even if there's some business reason that the witness would prefer not to talk about it.
Yeah, that's a good point, and this is a great question. I'm glad we cleared that up because it was a little surprising to hear that nonetheless. He was talking about the lack of chemistry between Jason Momoa and Amber Heard, so if you see a future Aquaman film and she's in it, I mean, this is going to be in everybody's mind. So, Linda, I have a question for you from Facebook, from Lindell Haywahi. Why hasn't it been presented that Amber Heard's own op-ed damaged her own career? What do you think about that?
Well, it is so interesting, Lindell, you asked that question because it's not just the op-ed, but it's all that's come out since, isn't it? And I think you may find that there's going to be some allusions to that in the final closing arguments, that Amber Heard, by coming forward with this, put herself into the limelight of the Johnny Depp supporters. They didn't like it. They went to Twitter, and they took over Twitter because you saw the spike in Amber Heard's Twitter and social media commentary was actually before any statements by the attorney for Johnny Depp. So I think that's a very interesting argument that I think we'll hear an allusion to by the Depp team tomorrow, or Friday, I should say.
So these are great questions. We're getting them all from YouTube, Twitter, Twitch, everybody. They're sending them in. And Gene, I want to go to you because this is a really interesting observation from somebody who's been watching our feed. This is from Jack W. on YouTube. How do you think the several times that Johnny Depp has laughed with his counsel will go down with the jury? I have been a witness in a case and found out later the jury did not like this. And I'll just let everybody know, the distance between Johnny Depp's table and the jury is very small. So, like, they can have a great view of everything that he's doing and seeing.
Jack, that is a phenomenal question. I talked about this about 10 days ago. Juries watch everything. They watch when you write a yellow sticky note to somebody. They watch how you touch your hair. And they are so close to Depp that it's impossible for them not to see his smirks, hear his snide remarks, or see his lips. I think the body language of Johnny Depp at the end of the day, regardless of the verdict, I can't believe the jury is not drawing a negative inference by some of the interactions that Depp has with his counsel, Mr. Chu.
So here's an interesting question that might clear it up a little bit. And Jeanette, this is from Gail Harrison Gibbons from Facebook. Why is Depp getting blamed for Waldman's tweets?
Well, he's getting blamed for Waldman's tweets because as his attorney, he is his representative, his legal representative. And oftentimes with high-profile individuals and in high-profile cases, attorneys make statements on behalf of their clients and in defense of their clients or on behalf of their clients. So you have to imagine, you know that Johnny Depp and Adam Waldman have discussed this. This is his personal attorney. So that is why Johnny Depp is being blamed for this by Amber Heard. It's called agency, and Johnny Depp, his agent, is Adam Waldman, so that's why.
Or at least that's the argument, you know. We'll see what the jury actually
Correct.
comes back with if they believe that he had this kind of authorization over him. We actually had a counter question to the one you asked, Gene.
Good.
But what if the jury's laughing at the same time? This is from Kingsley on YouTube. I'll answer that because I've been in the courtroom. I haven't seen them really laugh that much. I mean, they seem pretty stone-faced to me. But yeah, if they laugh, it'll be interesting. But look,
Sure.
but let's go now, Rich. I'll throw a question to you. This is from Dank Sean on YouTube. If the jury are randomly selected citizens, won't they strongly be biased since it's famous people? That's a fair question.
Well, they're certainly interested because it's famous people, but, you know, I guess there's an argument that there's famous people on both sides of this case, so they might be even-handed in that regard, although one is substantially more famous than the other. That's the kind of problem that you look at and you try to deal with in voir dire. That's the questioning of the jurors before they're even selected. You know, I think that's a factor in this case. But again, because there's a lot of celebrity on both sides and even some of the other witnesses, I'm not sure it's going to sway anybody one direction or another.
Well, I think a lot of people are swayed by the makeup conversation. They're swayed about whether or not Amber Heard used makeup to cover up her bruises. And I say this because, Linda, we have a great question from Debbie McCain from Facebook. Why didn't Johnny Depp have a professional makeup artist do a bruise on a person with the same type of skin color, hair color, to show how it could be done to appear like a bruise? A bit of a hypothetical setup here, an experiment, but what do you think?
Because let me just do something here. If it goes wrong, and I'll just bring out a makeup kit that I have here right now. If it goes wrong and I say, I'm going to take out this makeup kit and I'm going to put it on and I'm going to see if I can cover a bruise on my hand, and it doesn't really work well, the jury's thinking that you're really doing something for TV and movies, and you're taking the seriousness away from the case. Let me tell you, jurors all have common sense. They know when they get bruised, and they know how difficult it is to try to cover up any bruising they have, albeit maybe putting a Band-Aid on it, which doesn't look so good.
What could possibly go wrong? The glove doesn't fit.
Right, that's what I was thinking of, right.
The experiment never hurt anybody. No big deal. Tell you what, we're going to still take your questions. YouTube, Twitter, Twitch, Facebook, throw them in. We're going to answer them until the lunch break is over in about 30, 40 minutes. So stay with us here on Long Crime. We'll be right back. All right, welcome back, everybody. We're live right now in Fairfax County, Virginia, where we are on a special lunch break in the Johnny Depp Amber Heard defamation trial. As soon as that trial starts up again right behind me, we will jump live. But in the meantime, in this lunch hour break, Gene Rossi and I, and Jeanette Levy, Rick Schoenstein, Linda Kenny-Bodden, we are all breaking down your questions. Submit them on YouTube, Twitter, Twitch, Facebook. We'll answer them in real time here for the next hour, for 40 minutes or so, as when court comes back. Now, before we go to some more questions, I do want to play the testimony of Catherine Arnold, this entertainment consultant who testified yesterday for Amber Heard, saying that in her opinion, she thinks Amber Heard lost $45 to $50 million because of basically these alleged defamatory statements from Adam Waldman. Now, her testimony has been ripped apart today by various witnesses who have testified in Johnny Depp's rebuttal case. But to give you a sense of kind of the controversial nature of what she said, here's some of her testimony from yesterday.
Did Amber have a contract for Aquaman 1?
Yes.
How much was she paid for Aquaman 1?
Aquaman 1, she was paid $2 million.
Okay. And did that same contract provide for if she was in Aquaman 2?
I'm sorry, I apologize. Aquaman 1, I believe she got $1 million. Aquaman 2, she was supposed to get $2 million. I apologize. The numbers, there were a lot of numbers in that one contract. So Aquaman 1, it was $1 million. Aquaman 2, it was going to be $2 million.
All right. Now, based on your experience and knowledge in the industry, how much would Amber Heard have been able to negotiate her contract, but for the Depp-Waldman statements? For Aquaman 2, I'm asking.
Right. Well, as you can see from Mr. Momoa's contract, that went up exponentially, up to $15 million. Ms. Heard, I don't know if she would have gotten $15 million for the movie, but she certainly could have increased it by $1 or $2 million or even doubled it. So if it was 2, it could have been 4 or even 5 or 6, depending on the enthusiasm if it had just rolled from Aquaman 1 to Aquaman 2 without any of this negativity that was created by the Depp-Waldman statements.
What, if anything, happened to Amber's role in Aquaman 2 after the Depp-Waldman statements?
It was diminished.
What, if any, losses relating to production or film activities?
Well, again, these other actors that we looked at, and there's a wide range of them. Some of them did bigger films and some of them did gigantic films, but it is very reasonable to assume that once you are in an Aquaman-style film, you'll either continue to do those, right? Some of these franchises, as we know, go 4, 5, 6 films, or she would probably have been in another studio film that had nothing to do with Aquaman. But again, so over the course of 5 years, it's very reasonable to consider that she would have been in at least 1 film a year at a minimum of $4 million, because that's what her precedent would have been had she renegotiated. And it's important to note that in her Justice League contract, if there is a Aquaman 3, her price is set at $4 million. So it's very reasonable to assume and to believe that if she did a film a year for 5 years at a minimum of $4 million a year without any negotiation, which probably would have happened, but let's just say that baseline, that would be another $20 million over that time frame.
What, if any, opinions do you have about Amber Heard's earning power over time?
That it would continue to rise. It's customary in the industry, as I've talked about earlier, that the negotiations, especially with her agents at William Morris, her fees would have gone higher. So I'm just using the baseline without any ability to foresee in the future that I already know she got negotiated for $4 million from Aquaman 3. So if we use that as a baseline minimum, but it very well would have gone up had her agents done the work that they wanted to do.
So combining all of these opinions and calculations that you've had, what, if any, range are the losses you are estimating for Amber Heard but for the Depp-Waldman statements?
Right, so again, it's really important that I looked at, and hopefully you understand this, that it's over time, right? So let's just say a minimum of 5 years that we're going to talk about these losses, and it could be more, but at minimum, if you look at the film, the television, and the endorsement contracts, it's very likely that Ms. Heard should have earned between $45 and $50 million over that time period.
All right, and I want to focus on that for a second. We are getting some great questions. There's actually one from Twitch from JPC Guy 89 that I really like. I'll get to that question in a second. First, Gene, I'm going to go to you on this one. We have MP from YouTube who says, considering the testimony from the DC director, Walter Hamada, the big executive, what's the process to discredit an expert, meaning like Catherine Arnold, which we've seen a little bit today?
Okay, there's two ways to discredit an expert. One is you attack their qualifications, their training, their experience, their knowledge. That's the first line of attack, their resume. The second one is you attack their method of arriving at their conclusions. So if you use voodoo economics to arrive at a conclusion, if you use voodoo economics to arrive at 45 to 50 million in damages for Amber Heard, that to me is the best way to attack her credibility. And I got to say this, pigs get fat, hogs get slaughtered. If the jury thinks that 45 to 50 million is way exaggerated, that's going to hurt Amber Heard on the merits of her case, because it's really merits of the case, defamation, and then damages. It could hurt her merits argument.
Well, focusing on Johnny Depp's case, so Linda, I'll go to you. On Twitch, JPC Guy 89. Is this Johnny Depp's case to lose at this point, since the defense is quickly running out of time? Everybody's really focused so much on the clock. How much will it impact the defense's ability to prove their case?
Well, this is such a fascinating question, because we know that strategy is important. So, assuming the Depp team has, what, about 4 hours left, Johnny Depp can get on the stand as the last witness, be questioned till 6 hours maybe by his own team, and then perhaps by then there'll be no time left to cross-examine him. So yes, could it actually affect who wins and loses this case? If there is that credibility gap that Gene talks about, that the Heard team and what they're looking for comes out to be something the jury doesn't buy, they think it's ridiculous that they're being sold a bill of goods, Johnny Depp using his time could actually be the nail in that coffin. I first thought, Jesse, that Johnny Depp couldn't win this case, that there would be a draw, but I'm now thinking that maybe he can.
Well, listen, you know, if he's one of the last witnesses to testify and they don't have enough time to question primacy and recency, that'll be really fresh in the jury's mind, his last statements. All right, so Rich, we have a great question from Twitter. This is from Brigitte Supernova. Why didn't Johnny Depp's attorneys ask the doctor who actually treated his finger if the injury could have been caused by broken glass? This to counter the expert witness who never saw Depp, who never treated Depp, who claimed that such an injury could not have been caused by glass. I think that's a great question.
It's a fantastic question, Brigitte. Thank you for asking it. I thought exactly the same thing. When they put on the doctor, I thought that's where they were going. I thought he was going to counter that, because I got to tell you, I think that's one of the best expert witnesses that Amber Heard had. I thought he was rather convincing that you couldn't get that kind of injury from a broken vodka bottle, and I expected the doctor to counter it, so I assume that the doctor didn't know how the injury was sustained, that all that doctor did was repair it and put a cast on it, which was relevant to some other issue, but he wasn't in a position to counter the testimony of the expert witness.
Right, that testimony was really helpful to establish that if he had this cast on, he really didn't attack anybody like we had heard from Amber Heard's sister Whitney. It kind of discredits that, and we had talked earlier about how maybe there's going to be kind of rebuttal witnesses to discredit Whitney Enriquez's testimony. And Jeanette, good question here from Twitter. This is from Miss Kumalo. Couldn't some of the tweet spikes under the negative Amber hashtags also be caused by Heard supporters trying to support Amber Heard? So a little bit of a conspiracy here, that they would be deliberately trying to make her look bad online to say, look how strong her case is.
You know, that's a really interesting question, and the moment you posed that question to me, Jesse, something stuck out in something kind of came to mind. The other day when Amber Heard's agent was on the stand, she was some type of communications major in college or something like that. Ben Chu, she wasn't on the stand, I should say. Her videotaped deposition was playing. Ben Chu asked her, "What is a bot?" Okay? And she said a bot is a fake account created to achieve an objective. There was a reason that Ben Chu asked that question. Why would he just ask that question out of the blue? If you go on Twitter, you can tell who the bots are and who the new accounts are. It doesn't take that much. You just have to know your way around Twitter and social media a little bit. So maybe there's something to that argument. Johnny Depp, they're calling a social media person in rebuttal. So it'll be interesting to see what that person has to say.
All right, so at Miss Khumalo, maybe, you know, she's looking down the road. She's seeing how this case might go, and that could be a really interesting set of testimony there. All right, so Gene, we talk so much about, you know, Johnny Depp might lose this case, Amber Heard might lose this case. Great question from one of our YouTube fans, Clara Glusick. Since they're suing each other, can they both be found guilty? Well, liable here. Can they both be found liable?
Claire, that is a phenomenal question among many. Answer is yes. There could be aspects of each party's case that is pure defamation, and they each could get an award of damages sort of on both suits. Do I think that's going to happen? No. Because I think the jury's going to pick one winner and one loser. But I got to say this, whoever wins, I don't think the jury's going to be sympathetic to the damages, because they're going to conclude both sides were sort of going downhill, a slippery slope turned into a luge, and that they may have won their merits argument, but the damages, I don't think they're going to get the amount they're asking.
Yeah, they'll be like, okay, you each get $1. That's it. We all go home. No, I mean, it is an interesting question to ask nonetheless. I could see maybe a situation where they find her not liable for some of the statements in the article, but maybe liable for the sexual violence headline.
Yes.
Maybe they feel like one of the statements from Admiral Waldman was defamatory.
Right.
So it's a possibility. Want to get one more quick question in for Linda. This is from one of our listeners, one of our viewers on Twitch, from Av Boys. Is it typical for a witness to discredit or say another expert witness is wrong? If so, doesn't that seem pretty petty and unprofessional to the jury? Because that's what we heard, particularly from Richard Marks earlier today, discounting the testimony of Catherine Arnold.
Well, Adboy, the problem is when you have experts, they have to be able to comment on the other side's experts to rebut the testimony. Here, because Amber Heard had a counterclaim, she was also proving it in her presentation. Therefore, the first day I think of this testimony today is Johnny Depp disproving the counterclaim or disproving the damages through an expert. Tomorrow will be likely more disproving Johnny Depp's facts that or Amber Heard's facts that she went forward. But no, it happens in every single case. What you can't have is one witness commenting on another witness who's not an expert. That would be improper.
Nobody's making friends here at this trial, you know? That's the truth. Everybody's going after each other, but it's the way it has to work in these cases. All right, let's take a break. When we come back, we'll get some more of your questions.